Good afternoon. Welcome to today's webinar. My name is Attorney Abigail Planke. I'm an attorney here with Hooper Law Office. So we're a law firm based in the Fox Valley with offices in Appleton, Green Bay, and Oshkosh. We primarily do estate planning and elder law. So with that today, we're going to be talking about, what every power of attorney should know. There is a chance to be able to ask questions. There's a question and answer feature if you're registered and attending here live. You don't have to save your questions for the end by any means, so you can put anything that you might want to know right in chat or in that question and answer feature, and I'll answer as we go. We do, just so you're aware, have an option for a complimentary initial consultation. So we schedule our initial consultations for 2 hours with a kind of any attorney of your choosing, again, Appleton, Oshkosh, and Green Bay. So if there are any specific questions that maybe you want to discuss with an attorney after today's webinar, or just in general, know that that's an option. After today's webinar, you'll get an email with some materials. We have a handout on common errors when helping aging parents with finances. That'll be provided to you, as well as a feedback form, and you'll have the opportunity to sign up for an initial consult right there if that would be helpful to you. Otherwise, I'm going to start to talk about powers of attorney, and what I wanted to firstly identify is, just kind of bare bones of what is a power of attorney and why would someone have that. So there are typically just two kinds of powers of attorney that someone might have, typically a financial power of attorney. Also, this is oftentimes called a general durable power of attorney or a durable power of attorney for finances and property. It just means it's a power of attorney to make certain financial decisions. And then often there's a healthcare power of attorney, which is then going to be making medical or healthcare decisions. So by having a power of attorney, this doesn't mean that you have to change how you manage your finances or make your medical decisions. Oftentimes with powers of attorney, it allows someone to be able to help you make certain types of decisions if you'd like or need that assistance, or ultimately, really need that assistance because of a disability or an incapacity. So just by having a power of attorney doesn't mean that you need to change how you manage your finances or make your medical decisions. Often the word durable there is kind of the most important piece. Durability just means that this document is going to stay in effect if you were to become disabled or incapacitated. Powers of attorney ultimately end then when someone passes, so they're just for someone's lifetime. They don't, we're not going to get into detail really on like wills or trusts or other things that happen when someone passes. We certainly have other courses and topics on that, but powers of attorney again are for someone's lifetime. Really what it allows someone to do is almost like duplicating. You're able to do something and then your agent is also able to do something. It kind of just depends on how the document's written. So when you read the power of attorney, it'll talk about what's referred to as its effectiveness. It's kind of like when it starts or when it would come into place. So a lot of times, especially with finances, it's really common to read a healthcare power of attorney that says that this document starts when I sign it, so I can do these things or my agent can do these things. It doesn't limit your ability to do something, and so often it starts when someone signs it. Most commonly for finances, I'll give you an example with a financial power of attorney, like if you are traveling, or maybe your agent's your spouse and you can't be at a closing at a property because you can't get out of work or you're traveling for something, it would allow your agent to sign things just because you're unable to that day. Otherwise, powers of attorney more commonly with healthcare are what's actually called springing powers of attorney. So instead of the document saying that this starts when the person signs it, like it would if it was just immediately effective or immediately in place, a springing power of attorney most commonly will say that, once I'm declared incapacitated, which typically it says once 2 doctors sign off saying that I can't make, frequently my own medical decisions, now this person is able to help and do things. So when you read the power of attorney, you'll want to know kind of firstly who the agent is or agents. Oftentimes you have co-agents for finances. If you have co-agents, you'll want to see, do you have to sign together? Can either person sign and that's sufficient? So kind of and or. Most typically you'll want to do or. Very difficult for 2 people to sign one check. And then you'll want to know when the document actually starts. So its effectiveness. Is it starting when someone signs it? Is it starting when they're declared incapacitated? Is it something else? Most commonly, when you look at the state forms for some of these things, the financial tends to be starting when someone signs it, the medical tends to be starting when someone's declared incapacitated, although you can always choose that. You can have an immediately effective power of attorney for healthcare. You don't need to have it springing, and oftentimes, when I'm talking with clients about healthcare powers of attorney, we might really recommend that it's immediately effective. So that way, well, capacity isn't always something that's going to be very clear. And ultimately, with powers of attorney, you still want to be like making your own decisions for as long as possible. I'm sure if someone went from like, they're in their 40s, they're healthy, they're able to make their own decisions, there's no capacity concerns to, in an accident and a medically induced coma, of course, that's, black and white, and there are those cases. But there can be a lot of cases where capacity isn't necessarily this black and white idea, especially if someone, they're aging, they're starting to have memory concerns. It can often be really helpful to have a power of attorney that says, I can do this, like me, the person, or my agent can do this, just so what's helpful or convenient for me. So oftentimes immediately effective power of attorneys for healthcare are still a good choice or a good fit for someone. Now I'd like to talk a little bit more about each one of those specifically. So again, we've been talking about more like what are powers of attorney, why someone would have them, when do they start? A little bit more in detail on a financial power of attorney, or again, a general durable power of attorney for finances, what everyone's talking about, financial decisions, property management, bill paying, that sort of thing. So a financial power of attorney, again, doesn't mean that you have to change how you manage your finances. It mostly just kind of lists the person that you would trust to make certain financial or other decisions if you wanted or needed that support. So a lot of times, what's important to understand with a financial power of attorney is that you can really only do whatever the document says. So a lot of times, if you're familiar with the state financial power of attorney form here in Wisconsin, it'll have a list of like one-word authorities that you kind of initial next to. So if you wanted someone to be able to do, I'm just gonna pause for a second. Someone says, is this about keeping land and cottages in the family? That was, I think, like 2 weeks ago was our webinar topic, was keeping land and cottages in the family. Today is what every power of attorney must know, is what the topic for the webinar is today. I'm sure we can, if you email us, we can always get you a recording, I believe, of that keeping land and cottages in the family. I do see that kind of our tech support today can email you the recording of the keeping land and cottages in the family. I apologize for the inconvenience there, but that was what we had a couple weeks ago. Okay, excellent. So for a financial power of attorney, again, it really matters what authorities are actually contained in the document. So with the state form, often you'll see brief 1 or 2 word, initial here if you want someone to be able to do banking, or initial here if you want them to deal with real property and digital property and government benefits and things like that. So that financial power of attorney then doesn't actually go into a lot more detail as to like what banking means or what digital property means. That's actually elaborated on in the statute, which I don't expect any of you to know what the statute would actually go into more detail on. But it's just important to understand that that's further elaborated in the statute, and then whatever the statutes kind of say is what that person is able to do. Unfortunately, that financial power of attorney, especially the state form, is really not often sufficient for elder law. It can be really helpful for like, it's certainly better than nothing. A lot of times, it's important for your college age kids to kind of get these when they're going off to school, even if they don't need a will or trust or things yet. But specifically with the state form, it often doesn't allow for certain things that you might want your family to be able to do related to long-term care planning. So a lot of times when someone is starting to have concerns where they're not able to take care of their own finances, that often means that they're starting to have, maybe long-term care needs, whether that's they're bringing in services into their home, or they might start to be looking at an independent or assisted living. Sometimes they're wanting to figure out how they're going to pay for those costs. And this is, again, kind of ignoring any specific talk on long-term care today. Just understand that with a financial power of attorney, they can only do what the document says. So you kind of want to pretend like you're giving this document over to someone like a financial institution. You're saying, I need to, take care of this thing. I need to close this account, or I need to make a required minimum distribution from this thing, or I need to log into this account, any of those pieces that the power of attorney might say. And if your power of attorney document doesn't clearly say that, the company may say, well, you can't do this. The document doesn't authorize it. So understand that someone's power of attorney is not like a universal concept. Absolutely, there's statutory authority with the state. But there's no such thing as just being able to find the power of attorney so I can do whatever I need to. You might want that effect by having really broad powers if you have someone that you trust in this role, and you would want them to be able to do not only the things you can think of, but the things that might come up. So certainly having a broad power of attorney, especially able to do long-term care planning, would be to that person's benefit. However, it just matters what authorities are actually in the document. You can run into a point where the financial power of attorney is insufficient for whatever that person is trying to take care of. So if you're not sure what authorities you might need, or it's been a while since you've taken a look at it, it may be a good idea to have a power of attorney reviewed for finances, because with powers of attorney in general, there's something that you have in place kind of before you might really need them. Like you have it in place in case you really become disabled or incapacitated and now need someone to do something. And if that power of attorney document doesn't say that thing, well, in order for you to update it, you have to have capacity to sign. So it is really, really important that you have a good financial power of attorney in place for the people that you would trust before you would get to a point where you might not be able to sign new documents. So if ideally someone's wanting to have a financial power of attorney that's just in place if they need it or want it, and it has really broad authorities, the most important thing than otherwise is really selecting a good agent. So if you're a financial power of attorney, or if you're deciding who you'd want to have as a good financial power of attorney, I often tell families, you don't have to feel like you have to do any specific things. Like you don't have to name your eldest child as your agent. You can certainly do that if it makes you comfortable. You don't have to have a financial advisor as your power of attorney, or a bank, or things like that. There are professional options. But the most important thing is that you trust this person to have access into like bank accounts and make financial decisions. Because while a power of attorney is going to say that if this person accesses my accounts, if they go in for these things, they're just using it for my benefit, that doesn't necessarily mean that, someone's really going to be watching them all that well, or they're going to have a high level of oversight, especially if you're disabled or incapacitated. Now, if someone does something bad with the power of attorney, like they do things in violation of the power of attorney, like if an agent is stealing things or committing fraud against the person that they're assisting, absolutely, they can be criminally prosecuted, they can be held civilly liable. But those are very uncomfortable situations to be in, as you would expect. So trust has to be the most important thing when you're picking a good agent. And just for those who might be attending as financial power of attorneys themselves, you'll just want to keep in mind again that you can only do what the document says, and often you're doing this specifically for that person's benefit. There can be very high limitations or restrictions against things that can directly benefit you for purposes that that person wouldn't have normally kind of agreed to. So it really depends on what the document specifically says, what you're able to do. But again, a financial power of attorney is really just using that person's money to pay that person's bills, to take care of their finances, to give them what they need during lifetime when they don't have that ability often to do that management themselves. The next important thing besides trust for a good financial power of attorney is going to be like that responsibility or availability. So if you have two people that you really trust, and you can have co-agents for finances, as I said. So if you want to have, you trust both kids equally and they really want to work together, you can have them both together, oftentimes with independent authorities. But I really would factor in someone's availability to you. Like if you have a child who's very responsible, and and maybe even they have a background in finances, which again, you don't have to have. but they're very busy. They can't, get out between 9 to 5. Maybe they even work most weekends. It's going to be hard for them to call into businesses Monday through Friday, 9 to 5, and mail requests and do different things, because taking over someone's finances is a job. So you also want to be considering, and if you're that agent yourself, considering, are you not only are you trustworthy, but are you available and responsible? I don't want a procrastinator in charge of paying my bills. I'm sure you don't either. So the ability to get things done, to get in touch with the advisors, is really important for a good financial power of attorney. Their ability to make sure things are taken care of and that person really has what they need. With a healthcare power of attorney, then, if there are really no questions on the financial power of attorney, which again, question and answer feature if you have any questions. Healthcare power of attorney is similar to a financial power of attorney, but has to do with like someone's healthcare or medical decisions. So again, most common, a healthcare power of attorney, especially the state form, or forms that you might get through like an advanced directive planning because they use the state forms, or hospitals because they use the state forms or their own version of them, often say that once 2 doctors sign off that I'm unable to make my own medical decisions, now this person is able to make these certain decisions. And again, I oftentimes recommend just having it start right away. I tell my clients that I want you making your own medical decisions for as long as possible. But just like with the financial power of attorney, if you want help, you're recovering from a major surgery and you can't understand exactly what someone's saying, or you don't want to make a decision because you're under some sort of maybe painkiller influence, understand that healthcare power of attorneys can start immediately. They can be a springing. It depends on what the document says. So you'd have to read it to see when the document is actually going to start. But then with a healthcare power of attorney, most commonly this is going to be a lot broader than a financial power of attorney. Like financial power of attorney is very specific. Can you do this or not? It has to be clear in the document. With a healthcare power of attorney, most of the time it's just the ability to make certain types of decisions. Like, can you consent to different treatments and surgeries? Can you consent to pain relief? Can you admit someone to a facility? Can you make certain end of life decisions? All of those things give the healthcare power of attorney the broad discretion to be able to make certain types of decisions. That's why it's really important, if you're doing this document or if you're a healthcare power of attorney agent, that you have really good, frank and honest conversations with that person as to what their particular health wishes might be. Because ultimately with a healthcare power of attorney, you're asked oftentimes to make more broader decisions. We don't often put in specific language about I want this or don't want that, because we can never really predict where your healthcare is going to be. You want to have really good conversations with that person, make sure that they understand what your wishes are and that they're comfortable enacting them, especially end of life decision making, because they may be asked to sign off on an end of life decision. So if you talk with someone and then they start to say, well, actually, I'm not comfortable doing that, or that would be really difficult for me, then you may want to consider someone else. Or if you're that power of attorney and you aren't really sure where to start, I think there's something called like 5 wishes or 7 wishes that just kind of walk you through what different types of decisions are, and different things that you can talk about. But I often recommend starting with personal experience, personal things that you've seen, what you maybe liked or didn't like about that example, and kind of work through that. I do see a question. So if a state power of attorney form for financial may not be sufficient, what are other form options? There aren't other form options. The state form is the only one that you can kind of just go online and get. Most frequently what you do is actually have it reviewed by an attorney and they draft one specifically for you. So the state form is the only option that you really have as far as, I guess, a form. Otherwise, you'd have to go and have one drafted for you, again, with broader authorities. The state form is not intended to be specific legal advice. It's specifically not intended to be specific legal advice. So you would want to actually talk to an attorney at that point and have one created for you. It's just the state form is the state form. It's not intended to be legal advice. Okay. On the point with healthcare power of attorney authorities, there is one thing I wanted to say a little bit about, like the state form or the idea of allowing your agent to admit you to a long-term care facility. A lot of times clients will be afraid of saying that your agent may admit you to a long-term care facility because they don't want to go to a nursing home. And I can absolutely understand wanting to record your preference for remaining at home. But if the worst, was to happen and you were to necessitate nursing home care, all you're doing when you're saying no is actually forcing your agent to have to go through a court step first. So just know that it doesn't mean that you're not going to end up in a nursing home. It just means that they need to go and actually get a court order because they don't have that ability. So in general, what happens with someone if they just don't have powers of attorney is that they actually would need to go and get guardianship, or if those powers of attorney are not sufficient, you may need to go and get a court ordered guardian. So the alternative to not having powers of attorney in place is that you go to court and petition for guardianship, which ultimately is very different from powers of attorney, because powers of attorney are never by themselves removing someone's ability to do something. They're just kind of, duplicating or allowing someone else to help with certain things. With guardianship, the court's actually removing someone's ability to do something and giving that decision-making ability to someone else. So guardianship can be important for someone, like, for example, minor children whose parents pass away. The court has to, decide who guardian's going to be. That's important. If you have someone, an individual with special needs, where they, they need to maintain almost like a parent-child relationship above age 18, guardianship can be really helpful. But for most people, by having good financial power of attorneys or healthcare power of attorneys, it means that you don't have to go to guardianship court or get a guardian in place. And ultimately, guardianship court can be something that is expensive. It takes a lot longer with that court process. And it's also all like, most court processes, something that is public and that you can kind of see certain information on. Oftentimes with a guardianship court, the other concern that we have with powers of attorney is we're trying to get these things in place so that way we can assist someone in the event that they're unable to make their own decisions. And that's why you have them in place, to allow someone to be able to help make certain types of decisions. In guardianship, oftentimes what you're doing is trying to remove someone's ability to make certain decisions. So you have to be proving to a court why someone can't make a financial or medical decision. So there's doctor's reports and other things, but oftentimes what happens is there's multiple attorneys involved in a guardianship proceeding. So first of all, there's normally an attorney helping the family to petition for guardianship. So you have the attorney representing the family or the person trying to obtain guardianship. The court is going to appoint what's called a guardian ad litem. So a guardian ad litem is the attorney that's going to make a recommendation to the court as to whether or not this proposed ward is in need of a guardian. So they're kind of like that independent person that's going to be making that recommendation to the court. And then there can be another attorney appointed as well if the person who is the proposed ward says something like, I don't understand why I'm here. I don't need someone to be doing this for me. I don't need a guardian. I don't want a guardian. The court's going to appoint another attorney whose entire job is to actually fight against the guardianship. So that can put families in a very uncomfortable position of having to, under oath, say why this person can't make or should not make certain decisions in front of that loved one, and again in front of a judge. So either by not having powers of attorney to begin with, by having insufficient powers of attorney, or unfortunately even good sometimes with the powers of attorney, if someone is refusing or revokes it because they're at a certain point, you can still end up necessitating a guardianship. But for most people, by having good powers of attorney in place that are more than sufficient to cover the things that you would need, allowing you to receive that assistance in that more private way, you can really avoid needing to have a court-appointed guardian. And you want to make sure that you have powers of attorney in place prior to really kind of needing them, because someone needs to have capacity in order to sign them. And if they're at a point where they can't understand, then you kind of are forced into guardianship. Um. Okay, any other questions? And I did, we have our material on common errors when helping aging parents with finances. That talks a little bit more in detail on things that someone might be doing and how else they should be doing them. More in kind of written example. If I have some time, I can definitely run through those. But I really wanted today to really kind of explain how powers of attorney are going to be working. Some of the more pieces that you might not know just by reading them. And a little bit on guardianship. So when it comes to finances, a lot of times I do see where a child is the financial power of attorney or a person is the financial power of attorney, but they're on bank accounts as an owner. If you're accessing bank accounts as a financial power of attorney, you don't want to be listed as an owner. And I'll give you, unfortunately, an example. I had a client whose son stole $160,000 of assets from her over a period of a couple of years by making withdrawals from an account. And the police weren't really in a position or weren't able to pursue criminal charges in that case because he was listed as the owner on the account. So they said it was more of a civil matter. If he had been accessing it as the financial power of attorney, it would have been much more clear for them to say, hey, you have to use mom's money for her benefit. This is only benefiting you. This is a violation of what your authorities say. And then someone would have actually helped her with some of those problems. She just wasn't in a position necessarily to be able to afford a civil litigation attorney, as you can kind of imagine. So when you're helping someone, it's safest for you and for them to not be listed as an owner on the account. You want to be listed as the financial power of attorney. And then what to do with a payable on death or other things that happen when they pass, understand that the power of attorney is going to end. And depending on what their estate plan is, then you want to make an informed decision as to what you do with the beneficiary designation. But for the lifetime, you don't want to be on as an owner, you want to be on as a financial power of attorney. It also helps that agent too, because you don't want an argument that mom or dad's bank account is yours if you're getting divorced or sued yourself. You want to make it clear that it has nothing to do with what's going on with you. You're helping them in this kind of fiduciary capacity. With a financial power of attorney or healthcare power of attorney, you want to be really, really careful about when you pay family members for different services. So especially if you're a healthcare power of attorney and you want to be paid, or your parent wants to pay you, you're going to want to talk with an elder law attorney prior to making any payments, because with Medicaid, which I'm not going to get into too much detail on, without a notarized caregiver agreement prior to any payments, they're going to look at those as gifts. So even though you're paying someone for an actual service, when it comes to family, you've got to get that stuff in writing. Otherwise it can be a big problem. Let's see. If you have been kind of a pseudo financial power of attorney, but don't have anything in writing, and you've been relying mostly on logging into accounts with login information, you can't do that unless you have the document that says you have authority over digital assets. That access can get cut off, or let's say that like something happens where now you need to do something in person. Well, without the financial power of attorney document, you can't do any of that, and you're going to have to look at a guardianship at that point if mom or dad doesn't have capacity. So if you're just logging in to be able to pay certain bills, it is really, really essential that you get a financial power of attorney in place. So that way you don't run into a position where now you can't do something and you have real authority to be accessing that if you get questioned on it. Also, don't assume that your parents have these documents. Is something I often say. Don't often assume either that they're exactly what you need. It would be important if you're able to actually be able to review them, take a look, understand them, and have them in a place that you can access in the event of an emergency. I have a lot of clients that think that they have these in place, and then it turns out they never signed them. So if they're not signed, they're not sufficient. And if you can't find them, then they're obviously not very helpful to you. So I know a lot of times that privacy is difficult with older parents, but you just want to make sure that, you understand and they understand that when you access into accounts, when you make certain decisions, there is kind of that fiduciary relationship. And at the end of the day, it comes down to a lot to trust. Either they trust someone to have these documents or they don't. And again, there are professional options if someone doesn't have anyone that might be a good fit for some of these roles. So, okay, next week, actually, if you have more questions on like wills, trusts, different types of those questions, we're actually having a public seminar, next week, Wednesday. It's gonna be at 2 o'clock, 2 p.m. and 6 p.m. at the Bordini Center here in Appleton. So we're gonna be talking about like wills, trusts, a little bit more on powers of attorney, long-term care planning. That's a great one to attend. If you have specific questions on long-term care planning, actually, the week after, we're having a seminar on protecting yourselves and loved ones from the high cost of nursing home care. That's actually going to be at 10 a.m. and at 2 p.m. at the De Pere Community Center in De Pere. So if you have any specific questions on some of those topics, you can actually see a full list of our events and register if you go to estateplanninglive.com. So otherwise, thank you so much for your time. Have a good rest of your day.